Hello viewers, this is Dr. Kashinath Neharkar, Assistant Professor Sri Shivaji Law College, Barbhani. I welcome you to all to my lecture series on intellectual property laws. Today we are going to discuss different forms of intellectual property. So, firstly, we'll discuss which are those different forms of intellectual properties. Friends, general intellectual properties are divided into following categories. Firstly, we see which are those categories. The first kind of intellectual property is copyright. Second is trademark. Third is patent. Fourth is geographical indications. And next is industrial design. Apart from that, there are some other intellectual properties also, like the plant variation, semiconductors, etc. But we are going to discuss these only. Firstly, we discuss which is the first form of intellectual property, and that is copyright. See, friends, actually the word copyright is derived from word copier. This is the Latin terminology, and this means uh, to copy, or this word is related to multiplication. It means making more copies from one copy. Actually, this copyright is related to making copies, as I have already told you. See, copyright protects the creative work in a tangible form. It may, for example, it may be books, music, photos. See, in first lecture we have discussed the intellectual property is nothing but the creation of human intellect. It is creation of creative work of human mind. See, the copyright, when a particular idea is expressed in a particular manner in a particular medium, that work is uh, result of copyright. So the copyright that is created in tangible form. Say, when any writer writes any poem, that poem is written on a paper, or when a writer publishes his number of poems in a particular book, it is called as a book. Therefore, the copyright protects the creative work in the tangible form. Therefore, that work may be book, that work may be music, or that work may be photo also. It is available to author for expression of original thoughts and creativity. So copyright is available to always author only, and it is available only when that person expresses his original ideas in the form of books, movies, in the forms of poems, in the forms of thoughts, or whatever it is. See, if you try to understand what is copyright, again, the copyright is nothing but a bundle of exclusive rights available to author to do, or to authorize others to do certain acts like use, copy, sell, adapt, or distribute, or any similar act in relation to following works. These works are original literary work, dramatic work, musical work, and artistic work. Here, though the first number contains such works like original literary work, dramatic work, musical work, artistic work, we must understand what is the meaning of these terminologies also. See, original literary work. See, this is related to literature. What the literatures that are created by writers. These literatures may be stories, novels, etc. Dramatic work means the what dramas that are written by drama writers. Then musicians, what the musical work that is created by musician, that is also copyrightable work, that is also entitled to get protection in the form of copyright. It is intellectual property in the form of copyright of particular creator. Then artistic works are there. Artist means that artist who creates any work. That artist may be a photographer also. That artist may be any person who creates any artistic work. Then Another kind of work to which the copyright is available, it is cinematographic film. What the cinematographic films that are created in the form of movies, then any telecasted short films, etc., dramas in the form of telegraphic form, these are cinematograph form. Also TV serials also comes into this category. Then third one is sound recording. When any particular kind of work is recorded in the form of sound, that is also one kind of intellectual property. The person or the company who is responsible for the sound recording is entitled to get such kind of protection. So this is first form of intellectual property, which is called as copyright. So copyright protects the expression of original thoughts, ideas of creators, writers in the form of any book, novel, music, etc. Then we will move towards second form of intellectual property, and this second form of intellectual property is trademark. See, the trademark, this intellectual property is related to business or the trades. Firstly, we must understand what is trademark. See, trademark is nothing but any name, symbol, shape that is attached with any product or service, or that may be a name of any enterprises, or a mark which is capable of being represented graphically and which is capable of distinguishing the goods or the services of one person from similar goods and services of others. For example, these are the Lux, Godrej, TVS, Telco, 555 and Apple. These are some examples. We will understand these examples from these examples. But firstly, we must understand what is trademark. As we have discussed this definition, trademark may be in any form. That trademark may be in the form of any particular name, as it is shown in this picture, Coca-Cola. That may be in the form of any symbol also, like down to that bottle you can see the symbol of Nike, or that may be any slogan, that may be any shape. As you can see the shape of bottle also, that is also the trademark. That can be a logo like Apple, which is popular company of manufacture of mobiles, etc. That can be words like Godrej. That can be any number also, as you can see here the 555, or that can be the letters, you can see the letters 2s. So the trademark is nothing but any sign in the form of name, symbol, shape that is attached with a product or services while it is sold in a market. So here we can see the there are some functions of trademark. We must understand trademark is nothing but the symbol which identifies the producer of certain goods and services. See, when any businessman wants to sell a product which is of particular quality, and when consumer purchases it, consumer also gets satisfaction by using that product. Here the interest of trademark or businessman is that his consumer should again and again purchase his product, and again the interest of consumer is that he should get that qualitative product again. So when any businessman, when any trader sells his qualitative product, that product gets goodwill, and when he sells his product with particular mark, that mark also gets goodwill. That goodwill is nothing but what the reputation in the eyes of consumer. So what mark that is attached with that particular goods, that mark gets goodwill and that mark becomes trademark. So it is intellectual property of that particular industry. Therefore, trademark is a symbol which identifies the producer of certain goods and services. We don't need to know what is the name of that particular manufacturer. We just by seeing that mark with that particular goods, we can understand who is the manufacturer, or we get the particular kind of assurance about its quality and its origin. Second function of that trademark is trademark helps consumer to identify goods of known quality, because as the consumer is satisfied with the use of previously used goods and he wants to choose that goods again, the consumer by purchasing particular goods with particular sign, he knows that a particular good have particular quality, so he can easily identify, he can easily choose the goods of particular quality which is brought into market with particular mark. Then trademark saves consumer from the deception, because there may be many manufacturers selling the particular product into the market, and all of these goods and services may not have same quality which the consumer wants. Therefore, consumer can choose the perfect and the accurate product which is having particular quality and quantity which that consumer wants. Then we will move towards next intellectual property, and this intellectual property is in the form of patent. Friends, firstly we must understand what is patent. Patent is a monopoly document which is granted to inventor. A patent is a protection given to patentee for an invention for a limited time by the government for disclosing the invention. See, actually patent is available to inventions. Invention is nothing but a new thing which was not known to anybody, and that invention, when that invention results into production, creation of a thing which is useful for society, which is of commercial value, then that person must have a right to economically exploit it. Therefore, that person should be given an assurance that if that person discloses his invention and the government will provide him the assurance that nobody is going to steal his invention. Therefore, the patent is given for the patent is given as an award for the disclosure of invention. So the invention which is novel, novel means the invention which is new, it was not anticipated anywhere. Then secondly, the invention which involves the inventive step. The concept of inventive step means the advancement of knowledge which was unknown to any person who was expert in that field, also who is expert in that subject also. That advancement is called as an inventive step. Again, that invention must have some utility, that must be useful in any sphere of life, any field of human activity. That can be called as that invention must have capable of utility. And lastly, the invention must be capable of industrial application, so that invention must result into the creation of any industrial product, any product, etc., or that must be capable of being practiced in industry. Therefore, the invention which is capable of any novelty, the invention which involves novelty, which involves inventive step, the invention which have utility, and the invention which is capable of industrial application, the person who is owner of that invention is entitled to get the patent. Patent is nothing but an award which is given by government to that inventee for the disclosure of invention, and therefore patent is nothing but a monopoly document which gives protection to the invention and the inventor, and which enables that patentee to economically exploit it. Therefore, see, the patent right of inventor and enables him to exclusive right for economical exploitation of invention. So unauthorized use is prevented by grant of patent. Nobody can use the invention of patentee without his permission. So this is another kind of intellectual property. You can see the example of invention. This is the microscope which is invented by the scientist. Then next form of intellectual property is called as geographical indication. It is also known as GI in short form. See, geographical indication is nothing but the name or sign used on goods or products originating from a specific geographical origin or location. Therefore, it is called as geographical indication because that sign or name gives you the information about the production of goods and services in a particular geography or location. Therefore, see, what the goods that possesses unique qualities or reputation or characteristics because of its place of in particular origin, therefore that goods are known by particular geographical indication. So this is one kind of protection given to particular products and goods that are manufactured or produced in a particular geography or location. Therefore such protection is called as geographical indications. These goods have some uniqueness because of the following reasons: the goods are produced or products are produced at a particular weather or the environment and place, because it cannot be manufactured or such cannot be produced at other places, because for the quality production or it requires a particular kind of weather or environment. Then secondly, it is produced with special process or techniques or methods which cannot be produced outside or at other sites, therefore other places. Therefore that consumer wants that particular product because of its special qualities, what the special features. We can see some examples, like say first you can see here the petha from Agra. Everybody wants to eat the petha whenever he goes to Agra. This is the Darjeeling tea. This is also the geographical indication. Here you can see the Paithani sari. Then another is the Kolhapuri chappal. In every name you can see the geographical indication of particular product. You can see the santra from Nagpur. So this is also the intellectual property. This is also one of form of intellectual property by name geographical indication. Then we will see the next intellectual property. This intellectual property is in the form of industrial design. See, the design, it is also the creativity of human mind. This is also the creativity of intellect. Therefore this is also recognized as intellectual property. Industrial design is nothing but the right related to exclusive use of unique design of goods and products. Today we can see there are thousands of products which comes in a unique piece, unique shape, etc., unique designs. We can see there are many bathing soaps which have special kind of design, which have special kind of shape also, We can take the example of bathing soap like Moti soap, bathing soap like the Pierce also. Yeah, there are many products, even cars also comes in different industrial designs which are specifically reserved for particular manufacturer, because what the design in which they manufacture the product, particular product thing, that belongs to themselves, and this is protected in the name of industrial design. Here the right is related to appearance or the special design in which that product is created. You can see the particular Nokia mobile which was very popular in particular design. So this is also the industrial intellectual property, and only that owner of industrial design is entitled, he is enjoy exclusive right over that design. He can only make or manufacture product in particular design only. Other manufacturers, competitors are prevented from copying his design. This is also the intellectual property, because the exclusive right is available to that design owner only. Then we will move towards the next intellectual property, and this is trade secret. Friends, trade secrets are those formulas, confidential information, or know-hows about manufacturing or producing any products or the goods. See, therefore, these trade secrets are kept secret whenever there is an agreement between the owner of know-how and any person who wants to manufacture that particular product. They enters into an agreement, and that agreement is called as a know-how agreement or trade secrets, etc. Therefore, these products, the other persons are prevented from using the trade secrets or those information without his permission, or even the parties to that agreement cannot disclose that information to any third person without his permission. This will be the violation. So this is also the intellectual property. So friends, today we have discussed the different forms of intellectual property. If you like my video, please share it with your friends, and if you like my channel, please subscribe it. Thank you friends. Thank you.